of the major things we do around here are partitions. What is a partition? Well, it's dividing up a property, or it can refer to a forced buyout. What usually happens with a partition is a couple of different things. One, people might buy a piece of property together and it's no longer working out. More common, and what I see more and more often, is that children might inherit a property from their parents and their siblings, and they just don't get along with how to run the property or what to do with the property. Let me tell you about a few of the things that lead to a partition. One of it is financial need. Now that comes in two different flavors. Financial need might mean one of the co-owners can't afford the maintenance. They can't afford to pay their share of the taxes or the maintenance or the mortgage or their electric bill, and they can't keep bleeding money, so they want to sell the property or have the co-owners buy them out. Sometimes financial needs are different. Sometimes a co-owner needs to cash out. They have some financial need in their own life and they cannot wait for this property to become income producing through rent, or they just want to be done with it and just want their share converted to cash so they can move on with their life. Now, how do we do partitions here? Well, one of the first things we try, and it's often successful, is we do a pre-suit demand. See, partitions have specific statutes and laws and a whole process, legal process involving filing a lawsuit. But for our clients, we try to resolve things amicably at first, because often co-owners are siblings and it doesn't feel good to sue a sibling, or it's also time and money. So one of the things we do is we do a pre-suit demand. We say, hey, you have to buy out our client. They no longer want to be associated or part of this property. Sometimes that results in a deal for our clients. Other times, clients are ignored or the siblings haven't spoken to each other in years, so we have to take the next step to file a lawsuit. Now, Florida statute is very specific on the methods and how to do it. The bottom line is the property is going to end up being sold. Now, how much everybody gets depends on the method. So in the statute, for instance, the court could appoint a special magistrate to sell the property for what the magistrate thinks is fair value. Now, other times, if all the co-owners agree, they can put it on the market together and then get judicial approval of the sale. The third option is to put it on the auction block, and the co-owners don't get the value. They don't get the full value of the property that they would otherwise get if they just got along and agreed on somebody. By law, nobody has to own a piece of property that they don't want to own anymore. So the law provides different methods. Now, our goal is to get as much money for our client as possible. So obviously we try to negotiate a sale in the open market, and it's later approved by a judge. The other two methods, the co-owners might not get full value. Everyone talks about getting a deal on auction. We don't want that for our clients. Instead, we want them to get full value as much as possible.